The next case is State of Ohio versus Terrance Owens. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Morning. Let's start with reserve 5 minutes.
Thank you.
And may it please the court, I am Alan Medvick. I'm here on behalf of the appellant, Terrance Owens. We have raised one assignment of error, and that is that the trial court abused its discretion in denying Mr. Owens' pre-sentence motion to withdraw his guilty plea. And I would start by talking about the recent decision from the Ohio Supreme Court in Barnes, which I believe changes the landscape for these cases pretty significantly. What this court had used was a factor-based system, as did most district courts throughout the state. Ours was a little more limited than many of the districts use. They used a 9-factor system articulated in Peterson from 1980 out of the 8th district, which actually predates the G case, which stated the standard for such cases as pre-sentence, a plea should be freely, a motion to withdraw a plea should be freely and liberally granted. That court went on to say that there is not an absolute right to withdraw a plea for a pre-sentence motion. It's a confusing standard. It had no articulable measures within it, and so even though the Peterson factors were in place prior to that motion, courts have continued to use those, and I think to the detriment of that standard and to the detriment of defendants, including Mr. Owens here, where a reasonable and legitimate basis for that withdrawal is made, and yet we walk through these factors, which when you look at them, the criminal rules state that barring manifest injustice, post-sentencing, you cannot withdraw your plea. The articulable factors here are competent counsel was given a proper plea hearing at the time he entered his plea, was given a proper hearing at the time he moved to withdraw the plea. Was there prejudice to the state? These are all a way of parsing out, was there a manifest injustice? I think that these factors merge and slow roll our way to the same standard that you have post-sentencing. And that is not supposed to be the case here.
Would you agree that the factors are a balancing test then?
I think that the factors are not, what we have here is not a need for a balancing test. The articulable standard is, and is, as Justice Bruner says in her concurrence in the Barnes case, that if, and as the majority says, and this is a 4-3 case in Barnes, and the quote majority is a 2-person majority, and the concurrence from Bruner is a 2-person concurrence. I think because the main opinion is more narrowly tailored, that's the one that is the lead opinion. But that opinion says that in paragraph 21, it says that if we're going to be, if these are motions are to be freely and liberally granted, that if there is, that is the presumption from which your considerations should start. If there is a reasonable and legitimate basis for granting the withdrawal, it should be granted. And I think the balancing test is a burden shifting from that presumption that the defendant has a right to withdraw that plea.
But counsel, how do you determine what is a legitimate and reasonable?
Well, on a case-by-case basis, in this case, and in the Barnes case, there was additional evidence that was found, a video
Yes,
that had not been
Barnes
presented.
case was completely different than what we have in front of us.
And what we have here is a statement that my client was pressured into, that his retained counsel was gonna withdraw. There's nothing refuting that. The retained counsel was present, did not say that that did not happen. The judge, in her opinion, does not express that she did not believe those things. She just says he didn't follow up on it enough. As a layperson, that being told he's about to go to trial and that it won't matter if he tries to get new counsel.
Did your client plead on the day of trial?
No. I am not sure, let me be clear, I'm not sure of the timeline, if that was the date of trial, or if he was brought over a couple days prior to the trial date. I think it was probably a few days prior, if I recall correctly.
If it was a few days prior, even the day of trial, wouldn't that cause significant prejudice to the state to have a new trial?
I don't know that it would cause significant, does that outweigh the prejudice to my client being told on the day of trial he's about to lose his counsel, or less than a week prior? And his testimony is such that that his counsel came to the jail more than a month prior, and when he said, I do not want to accept, he started to say he doesn't want to accept this plea, that his counsel cut him off and said, we'll be back in a couple weeks. They did not come back, and that's how they spoke to him, was when he came to trial, when he came to the court and was told we're going to withdraw. You know, those are the facts that he articulated under oath in the record.
What standard did the court apply? You're saying the court should apply a different standard. What standard?
And
I know this is just a oral decision and not a written decision.
But
what standard did the court
I
apply?
believe that based on and I don't know that they articulated as clearly the factors here. I'm not sure that they went into the consideration of all these factors, except to state that he had competent counsel, he entered his plea knowingly. I believe that the trial judge said, you entered your plea knowingly, voluntarily, and intelligently. That was acknowledged at the time. You said you were not pressured into this on the record at the time. And basically she said, I think the plea's valid and I'm not going to allow you to withdraw.
Did the trial court make any mention of the Zero Barnes fact of the freely waiver granted the motion when the trial court articulated its decision on that?
I do not know if they made those records or from the bench. I know that the prosecutor articulated that standard and that factor-based standard in his argument, and both in opening and closing.
And the trial court only did that oral decision in this case. There's no written decision from the trial court on this motion.
I believe that is the case. And then we proceeded to sentencing. It may say that his motion is denied. There's nothing articulating, there's no specific findings regarding the motion to withdraw.
And did the trial court find that the testimony of the appellant in this case, the defendant, was not credible when the trial court made the ruling as to not?
I do not believe that there is any statement that she did not believe what he was saying. Simply that, in fact, I believe it's quite the opposite. Her statement seemed to indicate that he should have followed up more with his counsel when they were saying they were going to withdraw, or should have asked for new counsel, or should have done something different. She did not discount his testimony or declare it to be uncredible.
So part of the appellant's position seems to be that he's innocent. At least that was expressed by Attorney Graham, not recall if you mentioned that in your brief.
Yes.
Was there any presentation of facts or evidence on the record to show why he was innocent?
No, and I don't believe that you would. I'm not sure that that finding would have been. There was also, with all respect, I would argue that that is a shifting of the burden, even at this level, to have him need to articulate. He had maintained that he was innocent throughout, did not want to take this plea, felt pressured into it, and then to have to articulate why he would be found not guilty. I would argue that that's a shifting of the burden from the state's burden to find.
Well, it's a very unique standard, in that on one hand, we're saying liberally, freely grant, but still is a motion brought by your client, and the court, I think, says he has the burden to show reasonable, legitimate basis.
Yes.
So that burden does sit with your client ultimately. Would you agree that where the burden is on the motion, with the court looking that it should freely and liberally grant this, but it still is a burden on your client to have a reasonable, legitimate basis? He just can't show up and say,
Yes.
hi, I'd like to withdraw my plea, thank you very much, please let me. He has to show something.
And I think the question becomes, what constitutes a legitimate and reasonable basis? And with the application of this 9-factor or 3-factor test, that takes that out of the hands of judicial discretion and shifts this burden to basically making, as I said, creating a constitutional standard, a manifest injustice standard out of a reasonable and legitimate basis standard.
Counsel, let me ask you this, because this is very interesting. And if we don't have any factors,
Okay.
okay, because during my tenure on the bench, the way I've seen it, those factors have evolved in order to help the judge in the exercise of their discretion to when they're going to determine whether it's a legitimate, reasonable motion to withdraw a guilty plea, as well as the court in reviewing it. If we don't have any standards, what's to keep each trial judge from doing whatever they want to? And then ours is an abuse of discretion, and we can't substitute our judgment
And-
for the trial court's judgment.
I would contend that that's where we are now. And unfortunately, right now, in most cases where there is a presumption, and we have a presumption here, that if you can articulate a legitimate basis and a reasonable basis for wanting to withdraw this plea, it becomes, that burden shifts to the state. And it would
So
be
you're
the
saying he
state's burden to establish that that did not happen.
So the appellant can say, I was forced into this.
Yes.
Okay, and that's, in your mind, a reasonable, legitimate,
I think, and
even though they have said in the plea colloquy that they did it all knowingly, under oath.
yes, and if he's saying under oath now that that was not the case, and would say that we have all, and there is a line between what constitutes legitimate pressure, legitimate explanation of the case, and making clear that you may well lose this case, and if you do not take the plea, obviously there's always some aspect of pressure in any sort of discussion. I know I'm into my
You are,
five.
you do remember.
And I'll come back to this, but I want to say that I think the 9-factor test has become a matter of thoroughly, I think it has gutted the ability of a defendant to withdraw their plea pre-trial, pre-sentence. I'll come back to that.
You'll have 3 minutes.
Thank you.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we're asking that this court affirm the trial court's decision denying Mr. Owens' motion to withdraw his plea pre-sentence. I'd just like to start out by saying that 3 years ago on this day, the victim in this case senselessly lost his life. One of the victim's family members is present. The victim's family does deserve to have some finality. When defendants come into court and they enter a plea of guilty, they do bear the burden, if they want to withdraw that plea, of showing a reasonable and legitimate reason, and that burden is on them. This particular case, whether you look at the factors as a way to help a trial court decide whether their decision is within their discretion, I think is the way to look at it. We do have to find a way to let the trial courts know what they should look at so that we don't have, as the court indicated, we've got 10 judges at the Court of Common Pleas. We could have 10 different ways of courts analyzing whether or not to withdraw a guilty plea, and that's just in one court in particular. Barnes, in my opinion, did not gut the way that we've always examined the responsibility of a defendant to show that they have a reasonable and legitimate reason to withdraw the plea. While Criminal Rule 32.1 talks about withdrawing a plea before a sentence, and that the case law talks about it being freely and liberally granted, that does not mean that it's automatically granted. In this particular case...
No, it doesn't, but it does in Barnes, the court reiterated, those should be granted.
It should, if
They
they
should be
demonstrate.
doing, that's what, and again, it's a unique standard, we're starting from a premise that this should be allowed, so I appreciate the state saying there might be victim neutrality, but the reality of this rule is that until a person's sentenced, there's a different standard.
There is a difference.
Period. So, and it's a standard that says it should be freely legally granted.
Right. And,
If the court is looking at liberally and freely granted motion, does the court abuse discretion when it says, you're kidding me, when someone says they'd like to withdraw their plea?
so if the court had said, you're kidding me, and said nothing more, I would say that would be an abuse of discretion. But here you have a judge that has been working with this case for a significant amount of time. You've got a victim, obviously a victim-involved case. We have a death in this case. You've got a defendant that's been in court numerous times, was given another attorney for the, that plea motion. You can tell by the court's statement, right, that the court knew a lot about the case and was frustrated because you can tell the court believed that there had been a full colloquy that was given.
Or doesn't that make us raise a concern for us that the court had already decided the motion before it was even heard? Her comment that day was, I know I gave you an appropriate Rule 11 colloquy when I gave this plea. It wasn't I'll have a hearing and I'll review that. I've already decided to some extent. I couldn't be wrong. I've decided this is the case. And that's the exact concern that we have to recognize. The trial courts do put time and effort into resolving these cases and know what's going on. And are they truly looking at the motion like they should be freely legally granted?
So, and I hear what you're saying. I would argue that that statement, are you kidding me, indicates that the judge was very familiar with how that plea colloquy was handled and felt very confident that it was knowing, intelligently, voluntary made. That does not indicate that she was not very thoughtful and considerate of the reasons that were given at the hearing. That statement was made when they came in and he asked
I
her.
recall at the hearing when it took place and she gave her oral decision, it said she couldn't understand or didn't understand the basis he had for his attempt to withdraw his plea.
That was her statement after she heard the evidence and analyzed it, because his argument is, it is hard to understand when you say, I was coerced, I was forced, but at the plea hearing, you were asked, did you feel threatened by anyone? No. Did your attorneys do a good job? Yes. Would you like to have more time to talk to your attorneys? No. And then you come
Well,
back
it's hard to understand. She could find it not credible. She could say, look, I asked you these questions and now you're telling me something that I frankly don't believe. But it was fairly straightforward to understand. He was saying these folks came down and told him, look, you can't go to trial, you don't have enough money. That, too bad that where we're at today. It seemed to be that's what he was basically saying. And it's straight enough for enough to understand. She could have said, I don't believe you.
Right, and the record also shows that he also knew that he could get a court-appointed attorney. So I think that was part of her frustration and the way she
I thought he was
came out.
unclear about whether you believe him or not. He was somewhat unclear about, gee whiz, I didn't know I could get one so close before trial, and that wasn't something I'd ever done before. He had some experience in the justice system, had appointed counsel before, so he knew it would work, but didn't know I could do it at that late date. Seemed to be what he said.
With the way I read it was, he agreed that he knew that he had a right to court-appointed counsel. Whether he wanted to, express that maybe it wouldn't happen that close to trial, he could have asked. He did not ask that. So what the record reflects is that he knew that he had the right to a court-appointed attorney. And while a judge may have not been artful in the way that she expressed, I don't understand, your argument. I think when you read it in its totality, what the judge was trying to say was, I am familiar with this case, I did your plea hearing, we went through all the rights, you had an attorney with you, you indicated that you understood the penalty. In fact, on a jail call, you said 26 years ain't so bad, which goes to show that he understood the charges, he understood the penalties, he understood that 26 years when you're facing voluntary manslaughter, aggravated robbery, weapons under disability, discharging a firearm into a habitation or school zone with firearm specs, that's a pretty fair sentence. So
The trial court, though, in this case, uses just that, if I read the trial court decision, then again, we have the difficulty with not a written decision, it's a oral decision, so we're all trying to interpret that. I read her as using just a three-part test from Peterson, which is, did you have competent counsel? Did you understand our rule, could get Rule 11 appropriate warning, and did you get a good hearing? And all that's really telling me is what is a known intelligent voluntary plea, which isn't the standard that Barnes and Z give us. That to me is all she really, she did here, is that yes, you had a known intelligent volunteer. I don't dispute that in the case, in this particular instance, based upon her findings, but it's more than required by the CN bond. Is it not? Did she ever at any point indicate that this is supposed to be freely intelligent granted on the record or anywhere else?
I don't recall if she used that phrase. I know that she indicated basically that what we're looking at here is nothing more than a change of heart, which is not the standard for a withdrawal of a guilty plea.
We've said it, we have said that. It's in our case law, I don't necessarily agree with that. I think what we're really saying there is the opposite of that is you have a reasonable legitimate basis. And that's what the standard is from Z Barnes. And I think we're really just in some regard saying the opposite of that of it's just a change of heart if you don't have a reasonable legitimate
I agree.
basis. But I think she would find that to me to some extent without saying it what she was finding, but she never touched on your liberal and freely granting these motions.
I don't recall if that particular phrase was ever articulated by her. It was raised by the
The
prosecutor.
assistant prosecutor did say at that point in time, here are the standards, and gave a kind of closing argument that dealt with the prosecutor's view of our case law in particular.
Right, so it was definitely before the court. Whether or not she said that, I don't have that transcript in front of me, and it was not journalized. The journal entry for the sentencing talks about how the motion was denied. It doesn't go into that. And I don't want to misspeak because I just don't recall.
And that, thank you for reminding me, I do think that, as I read the sentencing order, just said this motion was raised and denied, and gave no further basis.
That's correct. But I do think when you read it over, that the court did consider more of those factors. I think that's part of, and I understand I'm reading into it, and I'm a prosecutor and I have a different, what frame of mind, I suppose. But I think part of the "are you kidding me" was it, according to the journal entries, and that's all that I have, I was not trial counsel in this case, that the date that they came in to do the plea was the date of trial. So, you've got a case that's been going on, you've got a trial date that has been continued before at the request of defense counsel, you come in on the day of trial expecting to, have a trial or a plea. The defendant, pleads out, and then the court, I would say understandably so, is frustrated. That "are you kidding me" to me solidifies that that was actually the trial date, and there were other people that were going to be coming in, and that does create prejudice to the state. It certainly is, inconvenient for the court. It is burdensome to the family and to other witnesses and folks that might have to testify. The scope of the trial court's consideration of the motion to withdraw, I think when you read through what the court had to say, the court did talk about the fact that there was a new attorney at the time of the hearing for the withdrawal plea, that there had been numerous continuances. So I do believe that the court did take it into consideration. I understand that some of the language that the court used, you could look at it just in black and white and say, is the court kind of just saying something off the cuff, or is the court pre-deciding something? But when you read the totality of what was discussed and then what the court said on the record, I believe that it's just inartful language, but the court did properly, adequately consider the motion to withdraw. The timing of it also looks more like someone who had a change of heart. I'm sorry.
No, that's okay, thank you, I wanted to let you finish. Did the state give any reasons for prejudice other than, I don't think they gave any at all, or they just give the typical ones you mentioned here? We've been set for trial all the time, we have witnesses, and I don't mean to minimize it, we have the family here, or the victim needs some settlement and resolution of these cases. Was there any specific prejudice beyond that?
Not beyond that, other than, there had been continuances given. We have, we made sure the defendant had another attorney appointed, so that's not, prejudice to the state. But just that the defendant's rights, as far as having counsel, were being taken into consideration. There were new dates that were given, but beyond that, I don't recall any other specific prejudice to the state that was raised.
In turning to what the defendant presented, there's some comment by Attorney Brevin at the start that he maintains his innocent or something to that effect, but was there in this case any notice of alibi or witnesses subpoenaed to your knowledge?
Not to my knowledge, no. And that is, of course, one of the factors of whether there's some type of a complete defense that could have been raised by the defendant, and I appreciate what opposing counsel is saying, that maybe they don't have to give all of that information, but at some point, especially on the date of trial, if there was a defense that was going to be mounted, we should have had that in the record. Alibi certainly would have had to have been filed before that date, which was the date of trial. And there is nothing in the record to indicate that. And like I said earlier, there is the defendant's statement that 26 years ain't so bad, quote unquote. So that to me is not showing any indication that he wasn't guilty either. And it certainly goes to show that he understood what he pled to, what the potential penalties were, and that he believed that the sentence that he received was fair. If there are no further questions, I would rest on my brief and ask that this court affirm the trial court's decision denying the defendant's motion to deny guilty plea.
No
Thank you.
questions? Thank you. Attorney Mendick, you have 3 minutes.
Thank you. Well, let's start with the trial date was December 19th, not December 11th. And I did have a chance to confirm that on the record. So this was not the trial date. There was time to reset this on the state's behalf to figure out what they needed to do. I know it's only 8 days, but it was not the trial date. Regarding that December 11th date, as I said, I don't know, as I said in my brief, I don't know how that was set, the date to bring that client over, to bring Mr. Owens over from the jail for that conversation was entered on the same date as he appeared in court. I don't know when those discussions happened, how they came about, who requested that he be brought over. He had expected his attorneys to talk to him at some point prior to that, and instead he's in court being told he has to plead and they're about to withdraw. That's his testimony. Regarding the statement about 26 years, not so bad. He also indicated in response to Prosecutor Salverson's statements there that he had also had different conversations where he was confirming this this concern, and that he had expressed that in separate calls to his family. Those records are not presented, nor was the call itself that said he said 26 years, not so bad. Regarding just Judge Carr's questions about the standard, one of the things I would state about Barnes is that no one in the majority applies those Peterson factors. The 4 justices who rule in Barnes in the majority do not apply those factors. Justice Bruner would disregard them altogether and have something else go on. I'm not sure that the decision of the lead decision is better, because it simply says, well, they don't apply here, and I don't know when you get to make that decision either.
But Justice Bruner could not get 4 people to vote for her.
No, but Justice Bruner also, but right now I don't know what happens when do you, to your concerns about, well, how do you sort this out? When do you decide that these factors are applicable? When do you, I mean, I am saying, and what I would articulate is that in any case where there is this presumption, just like in any presumptive standard, if the defendant meets its burden, it is then the state's burden to establish why that is not the case. And that is where I would argue
And
that
that
this
is
is the
completely different than anything anybody's ever done.
and that's not where we are. And I understand that, and I
It's
don't know
not
what,
where
I don't know what
Barnes, that's
Justice
not where
Bruner would,
anybody
I
is.
mean, I would say the standard is a legitimate and reasonable basis has to be articulated. And I think that has
Most
been in
we
this
can
case.
fairly say of Barnes,
What's
is
that?
that there are at least certain cases in the Supreme Court's view where these factors do not apply.
And it-
And at least one of those factors was if there's new evidence. So there are some instances when the factors don't apply,
Yeah.
but they gave us no guidance to figure out when the factors don't apply, but sometimes they don't, and
Absolutely.
maybe sometimes they do.
Absolutely. And
Attorney Mendick, your time has concluded. You have 10 seconds to conclude.
I think I've been very clear about what I would like this court to do. I would ask that you reverse the decision of the trial court, remand so that my client's motion to withdraw can be granted. Thank you.
Thank you.
All have a good day.
Thank you both for your presentations. This court will take this matter under advisement and issue a decision in due course. The clerk, of course, will mail you a copy of the decision on the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you.